Anybody that would like to speak, we have blue forms back. Okay. If y'all would fill them out, just hand them to me and I'll take care of that.
You ready to rock?
No, I need 18 more seconds.
18, 17. This meeting of the Escambia County Board of Adjustment, October 19, 2022, is hereby called to order. With 5 members present, we have a quorum. Will the clerk please swear in members of the staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Members of the board, copies of staff's resumes have previously been provided and remain on file for evidence. The board has previously recognized staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? Seeing none. The BOA meeting package for October 19, 2022 with the Development Services findings of fact has previously been provided to the board members. The chair will now entertain a motion to accept the BOA meeting package into evidence. Do we have a motion?
Motion.
Do we have a second?
Second.
We have a motion, we have a second. All those in favor signify by raising your right hand. Passes unanimously. Do we have proof of publication?
Yes, sir.
Did the publication meet all local requirements?
Yes, sir.
All legal requirements?
Yes.
The chair will now entertain a motion to waive the reading of the local advertisement. Do we have a motion?
Motion.
We have a motion. Do we have a second?
Second.
We have a second. Those in favor signify by raising your right hand. Passes unanimously. Members of the board, have you previously or reviewed the resume of the transcript for the board adjustment meeting held September 28, 2022? Upon your review of the resume of the transcript, are there any additions, deletions, or conditions? Seeing none. The chair will now entertain a motion regarding the hearing on September 28, 2022.
Motion.
We have a motion. Do we have a second?
Second.
We have a second. Those in favor signify by raising your right hand. It passes unanimously. The Board of Adjustment, BOA, hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing statements will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action and before making its decision, the BOA will consider the testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development orders for the approval are final unless overturned by a court of competent jurisdiction in the county, must have development orders and permits to progress in according with the decisions of the BO. However, if application requests, applicant and the county should bear any, and not the county should bear any risk that such decisions are made to aside. The development and or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the BOA for said action or any aggravated party as defined by the site law may seek new or review of such decision by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date whenever the BOA denies an application, no new application for an identical action on the same place may be approved for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision within 15 days, therefore, may apply to the circuit court for review. Each individual who wishes to address the board regarding the particular issue must complete a blue request to speak form, which is in the back of the room. These forms are located on the table, and the allowance in the law receive one of the completed request forms for the to be completed for public record. All written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communication. Ex parte communications are presumed prejudicial under the Florida law and must be disclosed as provided in the Board of County Commission Resolution 96-13. That is before a decision by the board of any administrative appeal, variance, or conditional use request. The chair will ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue to please identify themselves and describe the consideration. Our first case is conditional use 2022-15, 2405 West 9 Mile Road. Board members, has there been any ex parte communication regarding this item? Seeing none. Does anyone have knowledge or information obtained from the site, visit, or other sources? Seeing none. Does any board member intend to refrain from voting due to a conflict of interest? Seeing none. Would the individuals who are party to this item come to the podium, identify yourself at this time. Please state your name and address for the record and wait to be sworn by the clerk.
Good morning, board members and staff. My name is David DeShera. I'm with Engineering Design Group. Represent the applicant on this project and request.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
you have received a copy of the staff's findings of fact?
Yes, sir.
And do you agree with the staff's findings of fact?
Yes, sir.
Having said that, if, with your permission, we'll go ahead and have the staff give us a synopsis of the request, and if you just have a seat, and if you need to address it, we can call you back.
Yes, sir. Thank you.
Thank you.
All right. Good morning, Board. What I'm going to do is go ahead and go through the maps and photos, and then the staff findings following that. This is our location map. As you can see, the site is at the intersection of Surrey and West 9 Mile to the west of Pine Forest. This is the 500-foot radius map showing the zoning on site as heavy commercial, light industrial. Zoning to the south is medium density residential. Future land use category for the area is mixed use urban. Here we have a aerial map of the site. This is one of the public hearing signs that was posted. This is looking southeast onto the property from the intersection, just near the intersection of Surrey and West 9 Mile. Looking east from Surrey along 9 Mile. And that's looking southeast down Surrey from 9 Mile. And this is looking northeast from Surrey Drive towards 9 Mile. I'll move on to the findings. Thank you. So in this case, for this conditional use, the applicant is requesting conditional use approval to allow a drive-through within 200 feet of medium-density residential zoning. I've got the relevant code section there highlighted. It says the parcel boundary from any restaurant with drive-in or drive-through service shall be at least 200 feet from any LDR or MDR zoning district unless separated by a 50-foot or wider street right-of-way. And in this case, the districts abut each other. As to criteria, A, dealing with general compatibility. This vacant, heavy commercial, light industrial property fronts a major arterial roadway with commercial uses to the east and west. The parcels south of this property are residential in use and zoned medium density residential. Due to the outdoor aspect of a drive-through line, the LDC calls for this as a conditional use to allow for the application of conditions to reduce the impacts on nearby residential uses. The site plan submitted to DRC shows the menu board and speaker on the 9 Mile Road side of the parcel, opposite of the residential use. Through proper application of buffering standards, this proposed use can be compatible with the surrounding uses. Facilities and services. Facilities and services necessary for the operation of the proposed use are available to the site. C, on-site circulation. Ingress and egress will be via a driveway connecting to Surrey Drive, and the driveway will circle the building to allow for the ordering to take place on the 9 Mile Road frontage. The reason the site plan isn't proposing a connection directly onto 9 Mile, that is a DOT right-of-way, and that driveway connection would be too close to Surrey Drive. D, nuisances and hazards. The proposed use will require buffering to alleviate possible nuisance conditions associated with the drive-through. Solid waste. Solid waste service will be provided by the operator of the restaurant. F, screening and buffering. Screening between this commercial use and the abutting residential use will be required. Signs and lighting. Signage and lighting will be part of the site plan review process. Special attention must be taken to alleviate possible incompatibility uses with the residential parcel to the south. Site characteristics. The parcel is adequate to support the proposed restaurant use while allowing the drive-through amenity to be placed opposite of the residential use. these are specific use requirements. The proposed use complies with the conditional use requirements of HCLI zoning regarding drive-throughs. Findings, staff recommends that the board approve the proposed conditional use as requested. That concludes staff's.
Thank you. Board members, any questions of staff?
Would you pull up a site plan, please?
The site plan that we have is the only site plan we have. We have a survey. The site plan was one that was submitted as part of a pre-application for this site. We can pull it up, but it was a pre-application only. There's a number of issues to it that it's going to require quite a bit of refinement to the point of the setbacks. It's addressed off of 9 Mile. The setbacks are showing 9 Mile as the side yard and Surrey is the front and rear base that way. There's a number of issues to it. What we have here is the survey that was submitted for the piece of property. Keeping in mind, a pre-app is simply a first try at throwing something out there for the development review staff. Nothing can move forward in that regard without the use, the specific conditional use of the drive-through being approved.
What type of buffering or how wide of a buffering have they spoke about? 'Cause
So,
if we can't have the 50-foot, what are we?
well, now that 50-foot is regarding if there's a right-of-way in between
Right,
the districts.
that's right.
These are adjoining parcels. In any instance where you have a commercially zoned property that's being used for that, adjacent to residential, buffering is required, and it's going to, the site plan we have, it does reflect some of the trees that's there. There's a lot more trees on the site. Without an actual tree table showing me if any of those are protected ones that have to be saved,
Right.
there's going to have to be quite a bit of amending that proposed plan to meet the county's buffering requirements. We have standard buffering requirements, which they are proposing to supplement with an 8-foot privacy fence. The issue we're having, any site like this, we would prefer that as much of the natural vegetation as possible could remain without a tree survey sitting here. I can't tell you how many of those trees we're going to tell them you have to keep those and then supplement those plantings. It's going to depend on what's actually out there. Either way, DRC is going to hold them to that standard. They have to simply do it. It's a basic code requirement.
What square footage building are we talking about?
I would turn that over to the applicant.
It's 3,500 square foot.
And roughly how many parking spaces would you need for that?
Oh, gosh, I didn't have that in front of me. What we propose parking wise would be, to meet the, ordinance requirements for parking.
Okay.
I've actually got a set of plans. I could open those and show or give you that information if you'd like.
And you'll be, I know it says it in here, but you'll be accessing the property to and from ingress and egress from Surrey Drive. There
Yes, ma'am.
will be no access directly onto 9 Mile.
That's correct.
And will this require, according to some studies you've done, of any turn lanes or lights or anything like that? It didn't trip any of that?
No, ma'am.
Okay. And I know 9 Mile has changed, they've added lanes and so forth. What is the width of 9 Mile at this area? How many lanes are we talking about?
There are two eastbound and two westbound, and directly in front of us, I can't recall if there's a, I think there is a, well, there'll be a median cut for Surrey. And there'll be decel lanes for the turn lanes for that maneuver going southbound onto Surrey off of 9 Mile.
Okay, okay. Is there the median at that at that area, is it a grassed median area?
It's, no ma'am, it's a paved median cut for
Okay,
turning maneuver.
okay.
Would you clarify, the entrance to the property will be off of Surrey?
Yes, sir. Not sure if you're able to see that screen, or I guess it's in front of you.
Right.
So it's generically directly across from what you can see as the existing driveway that goes to the, I believe that's a pet store or a veterinary office there to the west. Yeah, so the proposed drive would be closely in line with that drive.
Can we get the aerial, please? Rachel, thank you.
The drive would be on the, adjacent to the south boundary?
Yes, sir.
Okay.
Close to it. Yes, sir. Yeah, you
Is-
can see there. Yeah. It, and to your question about 9 Mile, you can actually see the construction there. It's not complete, but in that picture it's not, but it is today complete.
So the buffering you're talking about would be on the south border of the property?
Yes, sir.
Where would the restaurant approximately be using the cursor?
Yeah, it's on the northwestern kind of side of the site there, where you can see his cursor there, or see the cursor.
And looking over this file last night, it's my understanding that the restaurant is going to serve alcoholic beverages?
I don't believe that's true. Yes, sir. No, that's not right. It's a proposed Panera Bread.
Okay, I just wondered, there was a reference to alcoholic beverages in the staff report.
That application covers all the conditional uses and all the variances. It's general application, and we do have a specific extra criteria for alcohol uses within 1,000 feet of a church or a daycare. It's just part of the application. It doesn't apply to this case.
Okay. And if, it's my understanding then, all the traffic that's going to be generated by this proposed development is going to be essentially dumped out on to Surrey, coming and going, is that right?
Yes, sir, that's correct. County does not have jurisdiction over 9 Mile Road's right-of-way. That's DOT. And there's not enough distance between Surrey and the entrance to the RV park to the east to allow for another cut right there at the middle of this property.
Yeah, so that would be for any applicant, I believe.
Yes.
You know, we've had these situations where we've had these traffic generators placed and into essentially bordering a neighborhood setting, and there's been a lot of outcry and upset that these kinds of things have caused because of the traffic that is going to be on that road.
So our LDC does have a prohibition based on certain criteria regarding access along a local street. It does, however, explain that we cannot, the county cannot prohibit access when there's no other way of getting to the property. A local street can be used when it is the only method of access. And like I said, we don't have jurisdiction over 9 Mile. Surrey is the only access.
And looking at this aerial overhead, how densely populated is it down Surrey? Seems to be a number of homes.
So there are homes on both sides of Surrey. Let me see if I can get an actual number for you here. I have 13 parcels south of this on Surrey. Surrey goes down to a cul-de-sac, and there you go. So there's 13 to the south.
How about multifamily? Do we have,
I believe those are all single-family homes. They're not, well, they're all, except for the bottom one, which looks to be a combination of two parcels. It's not a platted subdivision. These are all meets and bounds lots. But they are obviously have uniformity of size and are large single-family use parcels.
one thing I was noticing last night from the shots of the road doesn't appear to be in very good condition in places. How is extra volume of traffic is not going to be helpful to a street like that?
So any requirements for this parcel, this one project, required by the county would be limited to that stretch there in front of the parcel connecting to 9 Mile. The county would not be requiring this one parcel to pay for upgrades the rest of the way down the road.
Yeah, I would understand that point, but it does seem like that the potential for increased traffic is going to be magnified if this is approved.
If I may, since we're talking about traffic, I do want to make sure that we're aware too that, what we're asking for is commercial use, and, some of the other uses that are allowed here by right as of today with the zoning would be a gas station. They can go in there by right. A car wash could go in there by right. So, in terms of traffic, I don't know that what our use is going to be any more intense than what's already allowed there by right without a conditional use.
And the future land use is mixed use urban, heavy commercial zoning within a mixed use urban future land use designation does allow for strict residential at 25 units an acre. So multifamily housing could be put in there. I mean, the site would be limited as to how much, but most uses are allowed on that parcel by right.
Would buffering on that south property line include a fence, or is just vegetation or berms?
So it would need to be supplemented with a fence, vegetation supplemented with a fence, and they are proposing an 8-foot wooden privacy fence as their supplemental fencing.
We're definitely sensitive to that, and that's why we proposed kind of above and beyond what the fence requirements would be there for a buffer. I think 6-foot height is required. We've proposed 8 foot to help, including landscaping along the northern side of the fence to help soften any noise. Like staff's mentioned already, we put the drive-through on the north side to help with, order menu. The menu's facing northward. So the audible, you know, the ordering of that would be projected northward instead of southward. Definitely sensitive to the buffering of that, so that's what we've tried to address in our plan.
Did I understand you to say that the entrance to the drive-up is on the south border, but
The actual
where the food
drive-through,
is exchanged with money is not on that?
where the car sits in the drive-through lane to place their order is on the north side. Yes, sir.
Okay, thank you.
So basically, what you're here for, they're here for today is just for the drive-through. And basically, they could put a Panera Bread there today without a drive-through, but they're just asking to be allowed to have a drive-through.
Yes, sir.
I have a question also on the aerial, on the southern portion of the property. It appears that there are already trees existing on the property there. Are you going to eliminate those trees, or are you going to save? They look, I mean, it's hard to tell in an aerial, but they look fairly large and thick.
Right. So actually on the survey, we did locate trees on the survey. In fact, there's one very large tree in the northeast corner. It's very large, like a 100-inch oak tree. So we've definitely proposed to protect that and any that we can along the south side that's shown there. There's you can see some of the one live oak there. But we're definitely working with the plan as much as we can, including a landscape architect who's obviously the expert in that field for us on our team, to protect as much as we can. Some of those trees obviously are dependent upon their root system being protected, and being realistic with leaving trees, but also leaving trees that will last over time.
So would you be willing to leave as much of that buffer as, or as much of the existing vegetation as you have now as a natural buffer, and in addition to adding whatever else would be necessary?
Yeah, we will either obviously leave trees that can and stay, that aren't going to be disrupted from the grading operations, utility work, construction. Obviously, that's a tree that's mature. If it's able to stay, we want it to stay. If not, we've got landscape plans that would supplement those to be replaced.
Okay, thank you.
We have a couple of speakers. If you'll just have a seat, we may call you back in just a moment. Bethany Rittenhouse, would you come forward and be sworn in, please?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Just state your name and address, please.
My name is Bethany Rittenhouse. I live at 2740 Van Dorn Lane, which is 2 streets over from Surrey Drive. So I grew up on Surrey at 9155 Surrey Drive, which is the last house, if you can pull up that map so they can see. It's the last one towards the end of the cul-de-sac, the 2 lots combined. My sister lives at 9202 Surrey Drive, and we spend every day on Surrey Drive. There are countless children on that street, including 3 of my nieces and nephews. There are 2 small children that live across the street at Allison Burke's house. And those kids play every day in that street, riding their bicycles, not paying attention to cars. It's a dead-end street. It is a cul-de-sac. And my biggest concern about that going in there is, of course, the increased traffic, as you were saying. We love Panera Bread, so I do think it's a great place. I do think it is going to be very busy there, and I just don't know if that's the right spot for it. I do worry about, it is a quiet residential neighborhood. It has been that way for a long time, and so it would be hard to see just traffic going up and down that street, and I would worry about the safety of the children. My other concern, is you guys have already addressed, are the trees that are already existing on that lot There are quite a few of, I believe to be protected as heritage tree oaks. So if the plans do go through and you guys do develop, please try to keep as many as you can. There's a lot of clear cutting going around in that neighborhood, and it's hard to see as someone who's lived there for 25 years. So I guess some of my questions would be for the developers would be how many visitors on average does the Panera have? And how 9 Mile redistributed the turnaround right there. You can only make a right turn or turn left in the middle of the island, so it's not really designated for high traffic flow to be able to back up onto Surrey Drive, where those cars gonna go at 5 o'clock when everyone's eating dinner and exiting the Panera. So I think those are all my questions and concerns. Thank you for listening.
Board members, any questions of the speaker? Applicant, any questions of the speaker? Seeing none, thank you.
Thank you.
Would Alan Hawkins come forward and be sworn, please?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Right, thank you. Alan Hawkins, I'm actually the owner of the property, the developer, and we've been working with Panera for roughly a year and a half, trying to locate the best opportunity in this part of northwest Pensacola. And this site offers really the best site for them, and then really for future, hopefully, development based on the future land use. As David, my engineer, noted, there's 3 primary oak trees that we 100%, as of our current land plan that we've been working with staff on, are going to be protected. The one northeast corner, the 2 on the southern boundary, and we've accommodated that as part of our buffer, the landscape buffer, where the fence will also be located. So we're working as a starting point there, and then working with the arborist and our landscape architect to find the maximum way to protect the site and with what's existing. Several questions that were raised. Mrs. Rittenhouse? Okay. Access, the best place to place the access is actually across from the current driveway for the commercial use across the street. It's just a simple engineering principle. You want to align those so that you don't have a conflict. So that's where really the access needs to come, plus the billboard that presents itself, which I can't get rid of. They bought an easement from the previous landowner, and it's there in perpetuity. We had to work around that. So circulation, we believe, allows for both functional use and also for customers coming in and out to have a thoughtful means of in and out. They're not just coming out at an awkward place. None of those people should come south along Surrey. There's really no reason for any customers exiting Panera to come down that way. The average number of people per day, Mrs. Rittenhouse, let me see, do quick math. Probably going to be somewhere in the neighborhood of 300 or so. I'll have to frankly ask them. I'm just going off of, I know what their sales volume is and then what their ticket. So, but I can actually reach out to you and tell you that and bring that up. But it's not really, in the grand scheme of things, like a Chick-fil-A, McDonald's, all those things which present, you know, those people, that's more than 1,000 per day, just based on their volumes. This really is not a high volume type use. They're a great complement for a neighborhood, and we believe the highest and best use, as opposed to the other uses which are permitted under current code. I don't know if it's protocol allows me to circulate this for y'all. Is that okay?
Yep.
Okay.
The board would have to, here.
This is just architectural, I mean, this is the prototype building that we'll construct. And again, as opposed to other uses, we think it's, you know, one of the best looking quality, aesthetically pleasing buildings you'll find in the market, and that would actually, I think, allow for that corner to present itself and not be an obnoxious use like you could with a express oil or some other use which is permitted under code today.
If staff has no problem with admission of this, we would need to vote.
Yes, sir. What we've got here is architectural renderings, and it does show how the drive-through is positioned on the parcel.
Okay, board members, we would need a motion to accept that into evidence.
I'll move.
We have a motion, we have a second.
I'll second it, Mr. Chairman.
We have a motion and a second. Those in favor signify by raising your right hand. It's accepted unanimously.
And that shows there's, I believe, 3 copies in total, but it's all 4 elevations. So you'll see it from every perspective. Again, I think the most important part is we are presenting something that really is not the highest volume of traffic. And we're going to buffer on the south boundary line, keep as many trees, probably more trees than most uses would allow for, and work with the county on maximizing that. And we've gone to the extent of really finding the least, I guess, any type of nuisance that might be perceived as it relates to a drive-through use on this property. So I believe that this could be the best use you'll see from a restaurant with a drive-through component, which obviously is a conditional use, but I think really fits as it relates to 9 Mile. And the DOT they spent years, and they finally gotten all the West 9 Mile improvements in place. And the curb cut on West 9 Mile at Surrey was designed in such a manner to allow for access for it not to stack up. So people going west, DOT took that into account in the way they designed it. So in their perspective, I believe that the traffic concerns are somewhat mitigated by the fact that DOT knows more about traffic, I think, than anybody in this room. They designed these things for 40 years of traffic patterns. So hopefully that at least somewhat answers Mrs. Rittenhouse's question.
You indicated about 300 cars per day,
Not cars, customers.
customers.
Well, I guess that would be, excuse me, cars.
What percentage of those would you guess would be drive-up as opposed to eat-in?
Our previous traffic studies indicated somewhere around 110 cars per day. Panera is not, they are starting to become more drive-through. A lot of this obviously was COVID-driven. It just is a natural function. And that's why you see McDonald's and Chick-fil-A and all those go to 2 and 3 lanes of drive-through traffic because nobody wants to go inside. Panera is not that. The drive-through traffic, they really don't usually have more than 3-4 cars stacking at a certain time, as opposed to most fast food uses having 12 to 15 cars stacking. They're still primarily an eat-in, and it's about 75-25 is what they've told me currently in terms of customers sitting inside.
And the documents you provided also show outside eating area?
Large patios, they require that. It's roughly 350, 400 square feet of outside eating area. I mean, that's, again, part of their branding is they want people to come in, sit down, enjoy outside. The drive-through is just an amenity as they've transitioned through the whole COVID. I mean, the reality we're in as it relates to people not wanting, some people not wanting to come inside as much as they used to. So,
Thank you.
yes, sir.
I have a question.
Yes, sir.
You've indicated you'll be willing to save some of the trees. Some of them are protected, I think, by ordinance if they're that large anyway. Would you also be willing to save the understory, in other words, it's not very, in my mind anyway, very helpful in some ways if you save the trees, but the understory and the vegetation around it is removed.
Well, and going back to what,
In other words, would you leave it in its natural state the way it is now with the with the, not only, of course, the trees, but also the other smaller trees and bushes and that?
Well, as much as you can. My understanding, I'm not an arborist, forgive me, but the root system has to be protected, and there's an absolute bare minimum you have to basically work around. So it's by default going to save some of the vegetation you're probably alluding to. Now, to what extent depends on each tree and how those can be protected. Like the two oaks on the south side abutting the most prevalent residents, we've given at bare minimum, without benefit of scale, we've got about a total of 15 feet of buffer between the property line up to the first parking lots. But we've also added an additional area to allow for those two trees to have up to about anywhere from 8 to 20 feet distance before there's any improvements made around them. It's a natural protection zone, is what I'm saying. So I know we're working towards that. Same on the northeast corner, closest to the RV park. That's got a large green space area. It's approximately 50 feet, just east to west, with no disturbance. And then it's the entire length of the eastern boundary line is undisturbed as it relates to hardscape improvements. So it's got a large protected area.
Okay. And what about what types of vegetation are you contemplating to be added?
David, have we done our landscape plan yet?
I don't think we have the types defined just yet, but it would be, whatever trees are allowed by the ordinance to supplement anything that have to be removed. But so as far as the types go, I don't think we have that identified yet, but I would inspect something in the 3-inch caliber probably on some of the understory trees that are put back.
And what about shrubs and bushes?
Yes, sir. It would be included on the site. Now, to the detail of what they are yet, we don't know that just yet. But if you've seen a Panera Bread site, you know that they're going to have trees, shrubs, all your typical restaurant site landscaping.
Okay. All right.
Board members, any other questions of the speaker? Staff, any questions of the speaker?
No,
Seeing
sir.
none. No?
No, sir.
No. Thank you, sir.
Okay, thank you.
Would, it's not necessary, does staff want to make a closing statement before we call for the question?
No, sir.
Applicant, any closing statement before we call for the question? Seeing none, Chair will now entertain a motion regarding this item. In your motion, please state whether or not you adopt staff's findings of fact. If for any reason you do not accept staff's finding of fact, please go through each and all of the criteria and address each one specifically as to why you do not concur with staff's findings. Do we have a motion?
I move that we accept staff's recommendation.
We have a motion by Marty. Do we have a second?
Mr. Chairman, I'll second it with a proviso that there be the trees that are protected remain on the southern boundary, and that there be the addition of the 8-foot privacy fence and such other vegetation and that is required be put there to protect or insulate the neighborhood from the restaurant.
We have a second by Michael with conditions. Marty, do you accept those?
Yes.
We have a motion, we have a second. Any discussion? Those in favor signify by raising your right hand. Passes unanimously. Thank you, gentlemen. We have a staff presentation today, and we'll move on to that.
Okay. I have little handouts, if you'd like to pass that down. And I know you all have endured my presentation in the past, so I will try to keep it brief. The handout starts with the Sunshine Law and then midway through jumps to the Public Records Act. So I will, excuse me, start with the Sunshine Law, which is codified in Chapter 286 and provides that all meetings of any board of any county at which official acts are to be taken are declared to be public meetings open to the public at all times, and no formal action shall be considered binding except as taken or made at such meeting. So the purpose of the Sunshine Law is to provide the public with a right of access to all governmental proceedings. And the meetings of this board are considered a governmental proceeding that is subject to the requirements of the law because you are appointed members of the Board of Adjustment and you've been delegated certain decision-making authority to act on behalf of the Board of County Commissioners. So you are subject to the requirements. And the law has 3 requirements. All meetings must be open to the public. There must be reasonable notice of the meetings, and minutes must be taken. And thankfully, you have a lovely Madam Clerk who ensures that notice is provided of all your meetings, and she keeps the minutes for your meetings. So, your job as board members is to not interact with your fellow board members outside of a public meeting about any foreseeable action that may be taken by the board at a future meeting. And there are exceptions. You may interact with staff, your staff liaisons. And you may also interact with your fellow board members about matters that do not pertain to the board, that would not come before this board. Social interaction is not prohibited.
Okay, may I interrupt?
Yes.
Our interaction with staff, would it have to be public?
No. No, you may communicate with your staff liaisons, yes.
We just can't be a conduit between
Right.
you. That's all.
Right, and when you receive an email, for example, from Rachel, then it's always a good idea, and I think she always blind copies everyone, but just be careful if you receive an email not to reply all if you see your other board members are copied on an email. That's a good practice to avoid an inadvertent violation. There's also another exception for what's called a written opinion statement. If you wish, you may create a record. I would recommend you then send that to your staff liaison if you wish to have that distributed to your fellow board members outside of a meeting. And provided that there is no interaction amongst the board members and that record then goes to the next board meeting, then that may be distributed outside of the meeting and that would not constitute a violation. Now, jumping to public records, the purpose of the Public Records Act is to provide access to all public records of a state or local government, unless a record is exempt. And a record means any document or other material, regardless of its physical form or matter of transmission, that's made or received in connection with the transaction of official business. So any material made or received in connection with the official business that's used to perpetuate, communicate, or formalize knowledge is a public record. So if you make or receive a record in connection with the transaction of your official business on this board, then the record should be retained, and I would recommend forwarding a copy of the record to your staff liaison. And Rachel serves as your custodian. For your purposes, obviously, any of the agendas, any emails you receive directly from staff, those are already retained by the custodian. But if outside of that, you were to receive something that pertained to board business from a citizen or anyone else, then I would strongly suggest that that record should be retained, and I would forward it to Rachel or to staff, so that it can then be retained by the custodian. And that's really the gist of the Sunshine Law and the Public Records Act. Just trying to see it. Oh, another thing I also wanted to mention, under the Public Records Act, your personal notes, if they're not being exchanged with anyone else, they're just taken for your own purposes, then that doesn't constitute a public record. Does anyone have any questions? No? Always, if you have any questions or concerns, including any questions between meetings, if you have a concern about a potential conflict or anything of that nature, you can always email me directly if you would like some advice. Okay, that's all I have.
Thank you very much. We appreciate it. The next meeting is November 19th? No, November 16th. I believe we have a case you're working on, you said, or somebody is.
What I was mentioning is there is a project going through development review right now, that has a very high likelihood, extremely high likelihood of, coming before this board is, an administrative appeal. I don't know the exact timeline on it. It's one of these things that it would be a minimum of 45 days from the time a decision is reached, a bare minimum of 45 days. And with all of the holidays coming up, the end of November and into December, just depending on how that shakes out, we may well have to push that appeal hearing out until January. So, I'm waiting to hear on it. As soon as I know something, we will let you know, and we will try to start setting up a schedule for it. As far as November, Rachel, do you know of any cases we have? Okay. We may not have a meeting because we don't have anything for November. The administrative appeal, even if it were denied today, there's a 15-day window for someone to file the appeal. And then staff has 30 working days, not calendar days, but working days to try to schedule a meeting with this board. We're just going to have to see how that all shakes out.
And the makeup of the board may change because of the county commission races. I guess that would be next year, though, I believe.
I'm not sure. I mean, we do have an incoming
Yeah,
commissioner.
January, but there will be, the makeup will change.
It may or may not.
May or may not, or true.
That's up to the commissioners.
Anybody have any questions of anything?
I have a question for Rachel. Regarding the issue such as this meeting where you weren't sure if we were gonna have a quorum. I, for one, couldn't tell from the emails going back and forth if we were going to have one. And I have an hour drive to get here. what process can I use to make sure that there's a quorum or not, so that I don't drive down here and find out there is no quorum?
Right. By Monday I can, essentially what happens is by Monday, if I don't have a quorum, I'm sending another email, please let me know. And then there was, I think, Tuesday morning when I actually did get a quorum. So once I get a quorum, I can let you guys know, hey, here's who's coming and who's not coming.
Okay, I got an email Tuesday that said we need one more for a quorum, so.
Yes.
And I don't know if that meant, I was still left not knowing if we were having a meeting or not.
Right. When I sent that email, I sent it to you and Willie because you guys were the only ones that I haven't heard from, and you guys kind of emailed me at the same time.
Okay.
So at that point, I didn't say anything because then I had a quorum. It was more of if I didn't have a quorum, I was going to let everyone know.
Okay.
But as soon as I reach a quorum, I can go ahead and make another email, and then by Tuesday, before I leave, if I don't have a quorum, I could say
Okay.
that we don't.
I had responded to your first one, late, I think Monday, and so I wasn't sure if my attendance would make it a quorum or not, so that was my confusion.
Yeah, because I actually didn't get an email from you until last night.
Yeah, and I wondered if something happened to the first one.
Yes,
Okay.
yeah, I did not.
Okay.
But yeah, especially if you're driving an hour away, I could send another one.
All right, thank you.
I don't guess we have any legal cases outstanding now, do we?
Oh, yes, we do. And actually, the appeal in the MX United matter
Which
is now
one is that?
scheduled for oral argument. That was a restaurant that was, they were requesting a conditional use, I believe, on 9 Mile.
It was,
Oh.
yeah.
The Seafarer appeal is still pending, the beach access site. I think that's it. We just have 2 pending.
That's it.
What was that? I'm sorry, I didn't hear you.
The
on that
beach
one.
access site on Perdido Key, was appealed by a condominium called the Seafarer.
Right.
That's still outstanding.
Do we get notified when an appeal is approved,
When an order is issued,
yeah,
I always send staff, Drew and Rachel, the order, and I believe in the past, it's either been distributed at the next meeting or sent via email. I can't recall.
Oh.
It's been a while. But yes, I mean, we certainly keep you all advised of
okay,
the outcome. Sometimes it just takes a long time.
yeah.
The restaurant one was from last January, and the beach access was from multiple years back.
I think 4 years ago.
I think so. It's been a while.
So actually, the MX United case is moving remarkably fast.
So, what, there's gonna be oral argument or something in it?
It's scheduled in January.
Okay. And the Perdido Key one, that's still out there? What is it? Is anybody doing anything? I mean, not us, I know we are, but.
It's the appeal of the conditional use was the first action this board did on that. After that, there was an appeal there was an administrative appeal of the development order.
And that was not appealed. to
That was
circuit
not
court.
appealed. And the park is open and everyone's using it.
It may be that there is never a ruling. All we can do is wait.
Yeah. Wow.
It's been reassigned several times to different judges. It's kind of bounced around, but we've never received an order.
Well, that's something.
Anything else? Without objection, we're adjourned.